Hello, everyone, and welcome back to our employment law Q&A. My name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin LLP. We are the employment lawyers, and as usual, we are doing a live stream this afternoon for over the next half an hour to answer any and all questions our viewers have with respect to the world of employment law. If you're dealing with a difficult situation at work, maybe you've been let go from your job, maybe your boss is mistreating you, maybe you just have a question about a certain aspect of your work. Maybe there are changes happening within the workplace and your employer is asking you to accept a different position or accept changes to your job responsibilities. Maybe you've been temporarily laid off. Maybe you're dealing with a health issue and you want to know how to take some time off and take a medical leave of absence while protecting your rights as an employee. Any kind of question, any kind of issue that you're dealing with at work, there are employment laws in Ontario and certainly in Canada more generally that protect and guide you as an employee through these different and difficult kinds of issues. But of course, the law cannot help you if you don't know the way the law works. And that's why we do these live streams to help inform the public on what their rights are, what options they have when they're dealing with a difficult situation at work. Typically, we will start the show always with a bit of a case of the day or story of the day, as we call it. And I'll get into that, an interesting situation involving a maternity leave, in fact. But before that, I wanted to share our contact information. In the first place you should go, it's on the screen right now. Employmentlawyer.ca is our website. Go ahead and visit it right now for a couple of different reasons. Obviously, it's got all of our contact information there. If you're looking for a particular lawyer or a particular office, or you just want to call the main line, all of our contact information, of course, is online on our website. But as well, we've got a ton of resources on our website. We've got some employment law essentials that provide you with the very basics of the way employment law works in Canada. And just that could be useful in and of itself to know what basic and common rights you have as an employee. We also have lots of blog posts, lots of videos, lots of articles touching on really every single topic under the sun in the world of employment law. So if you're dealing with a very specific situation, maybe I wouldn't be surprised if you can find an article or a post or a video even related to that particular subject. And that'll get you on the way to just understanding at a very basic level, of course, the way in which the law works when dealing with your specific situation. Of course, none of that is a substitute for proper tailored employment law advice. And so, of course, if you want to reach out to us, if you want to have a conversation, and that's where we should start when dealing with an employment issue, we've always got to talk these things out. Go ahead and email us. Our email address is on the screen right now, help@employmentlawyer.ca. Very simple, help@employmentlawyer.ca. Go ahead and send us a brief email. Give us a brief description of the kind of situation you've been dealing with. If you've been let go, let us know. If you're dealing with a specific issue while employed, of course, let us know some of the details there. And I promise someone from our intake team will get back to you, likely to schedule a call and discuss the situation with an employment lawyer or with a paralegal who is both experienced and well-versed in the way the law works when it comes to these kinds of situations. And of course, if you want to give us a call at the office, the traditional way, go ahead and give us a call as well. It's a toll-free number, so feel free to reach out. Do keep in mind, however, a couple of parameters here. Number one, we've got offices in Canada, specifically in British Columbia, Alberta, and Ontario. If you're in the US or if you're anywhere else in the world, consult an employment lawyer in your jurisdiction. If you are in the United States, employment law is very state-specific, unless you're working for the federal government or a federal agency. And so consult an employment lawyer in your state and in your jurisdiction if you're anywhere else. But if you're in those provinces in Canada, go ahead and give us a call. More than happy to have a chat and again, discuss your issue in detail and provide tailored expert advice. At the very least, even though not every situation is perfectly manageable, not every situation is easily resolvable. Some situations are, of course, easily resolvable, but some, of course, are complex. you at least want to have that conversation to know what options you have. Where do I stand if I'm dealing with a difficult situation with my employer? Where do I stand? What options do I have? And ultimately, the key question is, what's my best option? What do I do moving forward? We have those conversations with people every single day, and always employees, the people that we speak with, are content that they have that information, that they've received that proper advice, and that they know where they stand. It is a weight off their shoulders to understand what they're dealing with and the way the law works in their particular situation. It's worth mentioning employment laws in Ontario are very protective of employees. Certainly, when it comes to severance, our severance laws in Ontario can provide significant compensation to employees, but also when it comes to things like temporary layoffs, changes to your employment, certainly harassment in the workplace, discrimination in the workplace, which I'll get to in a minute now. In all of those situations, again, our employment laws are very protective of employees. And so if you're dealing with a situation at work and you are wondering whether what you're doing, whether what your employer that is doing is proper, is fair, or even is legal, chances are you're on the right track. That gut feeling that you'll have about your employer likely means that something is wrong and that the law should be stepping in to provide some protection and potentially compensation. So don't ignore those instincts. Don't ignore that gut feel that your employer is doing something inappropriate. Speak with an expert, speak with someone who's going to be in your corner and can give you proper advice and guidance as to how to resolve that situation. That's ultimately what you're looking for, a resolution. All right, very quickly, and for those of you just tuning in, by the way, this is a live Q&A. We are live right now, and the goal of these live Q&As, of course, is to answer any and all questions that you have. So if you're tuning in and you're curious about an issue in employment law, maybe you're dealing with an issue at work, do not be shy. Go ahead and post your question. Keep it brief, keep it confidential. I don't need to know who your employer is. You can refer to somebody in the third person, of course. You don't have to make it specific or provide any kind of detail that might let the cat out of the bag. But go ahead and post your question. I promise before the end of this live stream, I will get to it. And I see a couple of questions already from Pine, from Bill, from Snipple. That is great. Thank you so much. Stay tuned. I will get to your questions and ultimately answer your questions momentarily. I did, however, want to share a little bit of a story that came across our firm and that we're keeping an eye on as we move forward. And I wanted to bring it up because it's something that happens often, that we see often in the world of employment law, and it's related to terminations of employment, but particularly terminations of employment not long after an employee has raised an issue with respect to a protected human rights ground. Now, what do I mean by that? Well, in this specific case, a lady that was working for a large tech firm recently announced that she was pregnant and expecting a child. Not long after that announcement in the workplace, and quite surprisingly, she was let go from her employment. She was terminated. And it raises the question, of course, of whether her announcing her pregnancy had anything to do ultimately with her termination. And we get lots of questions about this. Are employers allowed to let employees go who are pregnant or going on maternity leave or even taking a parental leave, as another example? And by the way, the reason why I wanted to mention it is this applies to really any protected discriminatory ground. What I mean by that is if you announce to your employer that you're having to take a medical leave of absence because you're dealing with a health issue, that health issue doesn't have to be work related, to be clear. Your health issue can be outside of work. And by the way, to add a second layer to that, it doesn't need to be a physical health issue. If you're dealing with a mental health issue, that is just as valid as any kind of physical issue. And if you tell your employer that you're dealing with these issues and they then punish you, terminate you, or demote you, or change your job responsibilities because of that, that is discrimination in the workplace. And the same thing, of course, applies to pregnancy and parental leaves and maternity leaves in the workplace, an employer cannot, absolutely cannot decide to let an employee go because they've announced a pregnancy or because they are having to take a maternity leave or a parental leave of any kind. That is discrimination in the workplace, point blank. Uh, Even if 1% of the reasoning, the rationale for the decision to terminate is related to that parental leave or maternity leave, it is going to be found to be discrimination under the Human Rights Code in Ontario. And again, the same thing would apply for other provinces as well. It cannot be part of the decision making process, not even 1% of it. And again, I raise this because, of course, there are going to be women out there who are pregnant and expecting and having to announce this in the workplace to their employers and might be nervous doing so. They shouldn't be. They are very well protected in these situations. And again, the same thing applies if you're taking a medical leave of absence or if you're dealing with some sort of health issue in the workplace. Do not be shy to tell your employer that you need accommodation. That accommodation is legally obligated. The employer has to accommodate the employee, and it could be in the form of a medical leave of absence, and it could be something else, a change to your schedule, change of job responsibilities, perhaps. Keep in mind, when it comes to medical leaves of absence and accommodations in the workplace with respect to physical or mental limitations, you need a doctor's note. Your employer doesn't need to know what the diagnosis is. They don't need to know exactly the health issue that you're dealing with, but they do need some sort of guidance with respect to either how long you might be out for if you're taking a medical leave of absence, or what kind of accommodations you need in the workplace. That information shouldn't come from you personally as the employee, it should come from your doctor. And that's what a doctor's note should look like if you're having to provide one to the employer. Interesting, difficult situations for employees, but I share this information only because employees need to know when you're dealing with these kinds of discriminatory grounds in the workplace. Employees have lots of protections, lots of rights. Employers need to tread very, very carefully when they're dealing with an employee who has raised an issue that might fall under a protected grounds under human rights legislation. By the way, if you're an employer, if you're an HR person, if you're the owner of a business and you're tuning in, be very careful when you're dealing with employees who have raised issues about taking time off for medical issues. Of course, mothers who have announced that they're expecting, that they're pregnant. Family status and family obligations may trigger obligations on the employer as well. If a child needs daycare and perhaps the employee is the only person that could care for that child, they may be allowed to take that time or to change their schedules even to care for that child. And there are lots of it, and certainly making decisions with respect to employment on race or nationality or religion, of course, improper and also protected grounds when it comes to discrimination. Be very careful, of course, in those situations as an employer. If you have any doubts as an employer dealing with employees in these realms, make sure you get employment law advice before you make any kind of decisions with respect to these employees. I actually spoke to an employer this morning that was dealing with a similar situation and provided the employer with guidance, and they have now a much better sense of how to handle these situations. They are very delicate. All right, with that out of the way, we are going to get to your questions, everyone. So let's get the ball rolling here on this Q&A. The first question was from Pine. Pine says on YouTube, I believe, I'm in Ontario and was just fired from my retail job after a single customer complaint. Despite a strong record and no recent issues. There was no warning or formal process, just a phone call and then an email confirming termination. They have offered 6 weeks severance plus vacation pay and an extra 2 weeks if I sign a release. If I sign a release waiving liability, could this be wrongful dismissal? Am I entitled to more? And would signing affect my EI or legal options? Pine, first things first, yes, signing a release. So a release is a document that will either be part of a termination letter or maybe an attachment to a termination letter that's going to look very legalese, very dense in the language. And it'll likely be marked full and final release, or final release as the title of that document. And what it will effectively say is that in exchange for the offer that's being made to you in the termination letter, it'll be some sort of amount of severance, that you are effectively releasing the company, that's why we call it a release, from any further obligations. I expect, Pine, from that comment that you'll know that if you do sign that release, you are absolutely affecting legal options, because you are effectively accepting the offer that is in the termination letter and saying that that's it. That's all you're going to owe me. We are done here. That is what a release means. A release means I will not be able, if you sign it, I, as the releasee, will, or excuse me, as the releasor, will no longer pursue any further legal options or entitlements I may have. And so you only want to sign a release when you are 110% certain that what you are being offered is fair, is reasonable, is legal, and that there are no outstanding issues or claims that you might have. So let's get to the other questions. Pine, you were offered 6 weeks severance plus an extra 2 weeks if you sign the release. So in other words, a total of 8 weeks of severance pay. 8 weeks of severance pay uh, uh, may or may not be a reasonable offer. It's likely unreasonable, Pine. We would need to know a couple of things in order to assess that severance offer. We'd need to know your age, your position, and your length of employment with the company. You mentioned your retail job. I don't have your age. I don't have your length of employment. And those factors are very important. Keep in mind, the older you are, the longer you've been with the same company. And of course, your position matters as well, the more severance you're going to get. I suspect, Pine, that what you are offered are your absolute minimum entitlements under the Employment Standards Act, plus a couple of weeks' pay. And typically, that is nowhere near enough for a severance. Severance could be as much, by the way, as 24 months of pay. It's 2 years of pay. Now, mind you, that is particularly for older employees, for long service employees, potentially even for management level employees. So if you're on the younger side with maybe only a few years of service, again, we need that information in order to assess. My guess, Pine, is that it's not enough. What you can do, and you saw the website on the screen not too long ago, do yourself a favor. It's completely free. It's completely anonymous. Go to pocketemploymentlawyer.ca, input your age, your years of service, and an approximate position, and you will get a very good sense of what your severance entitlements are. It's a severance pay calculator that we have used for many, many years now. And by the way, at pocketemploymentlawyer.ca, you can also ask other questions, and it's all free. It's all confidential. You can provide your contact information if you really want to, but you don't have to. It's for your information only. Go to that website, Pine, input that information. If what the severance pay calculator tells you is that you're owed significantly more severance, or even just a little bit more severance than what the company has offered, you absolutely need to have a conversation with us. And I can assure you that we will help you get that proper severance that you're actually owed. Do keep in mind, to address maybe some of the points you raised initially in the email, listen, keep in mind that, and this is particularly true in the non-unionized environment. So if you're a unionized employee tuning in, works a little differently because you've got the union backing you up here. But in non-unionized settings, keep in mind, Pine, you can be the best employee in the company, you can be an average employee, you can be a slightly subpar employee. That doesn't change what kind of severance you're owed. Your severance entitlements remain the same. And so whether or not you had a strong record, whether or not you received one customer complaint, you are still owed severance regardless of those issues. But at the same time, your employer did still have the right to let you go. Your job is not protected indefinitely. An employer can decide to let an employee go really for no reason at all. It's what we call a without cause termination, meaning there's no real reason for the termination. They could just decide to part ways. The legal obligation, however, that flows from that breakup, that flows from the employer deciding to end your employment, is the legal recourse of severance. And so this is a severance claim, Pine. I suspect you haven't been offered enough. Give us a call at the office, send us an email at help@employmentlawyer.ca. And as a starting point, use pocketemploymentlawyer.ca to get you on the way to getting in touch with us and figuring out whether the severance they've offered is appropriate. All right, next up, with quite the long message, I'll do my best here, is Bill. Bill asks, my wife is a caretaker and has been working for a family for 7 years. She got injured on the job, moved some heavy tables. She mentioned this to her employer prior to going away on vacation. I'm going to try and speed this up. Bill, she produced a doctor's note for 7 days. She went to her own family doctor. And looks like the family that she was working for continued to harass her by text message. She does not want to return to that job, as it's a terrible, toxic environment. Now they're harassing her during her sick leave. Can a firm like yours represent her to arrange for a departure package, as the trust in the relationship has been eroded? My apologies for the long message. Bill, it's not a problem. Listen, if you didn't get all of the details in that message, email us. Email us at help@employmentlawyer.ca. It's probably worth your wife and one of our representatives, Bill, and yourself for that matter, if that's preferred, have a conversation. Let's talk it all through. I want to know the details. Certainly, this is a situation where we can assist, because if your wife is being badgered while on sick leave by the family that she works for as a caretaker, that is inappropriate. That is not proper conduct of an employer. They should be letting her convalesce, letting her get better, and leaving her alone. Whether or not a departure package, Bill, is appropriate in the circumstances is a bit more of a complicated question to answer, and one that probably requires, again, a bit of a conversation. And I'll put it this way, and it's not to overcomplicate things, but the devil is always in the detail. If the family's behavior, Bill, has been so severe, so toxic, to the point that it very obviously reaches the legal definition of harassment in the workplace, and is very obviously and patently problematic and unacceptable for workplace conduct. And for example, if a lot of that stuff is easily provable by text messages or emails, then this is a situation that would be considered what we call a constructive dismissal. It's basically a breach of contract. To put it in other words, if an employer's conduct is so severe, so problematic, so harassing and poisoned in nature, it could represent a breach of contract. And that breach of contract would then allow the employee to seek severance, despite the fact that they weren't out and out terminated from their employment. It's a relatively high bar, Bill, so we would need to show that their behavior was severe. If you can do that, then we can discuss departure package. A lot of employers will be inappropriate, will be unprofessional, but won't necessarily cross that threshold of legal harassment in the workplace. And so it's always something that we've got to assess. And it is a very tailored, very specific assessment in each individual case. Bill, I think it warrants a conversation for sure. Give us a call at the office. Let's have a conversation. You've got to do it. Just, sitting there in silence, not responding to their text messages while your wife is on sick leave, it's not the answer. So please reach out, send us an email, give us a call at the office. Snipple is up next. Let's see. Snipple says, I've been working remotely for the last 4 years, and now my employer is talking about returning us to the office. I moved because I was working remotely and cannot commute in anymore. Can they fire me? Snipple, very interesting question. I will give you the brief answer first and then expand a little bit. And I actually said this a couple of minutes ago, and the same logic applies. At the end of the day, Snipple, yeah, they can fire you. They can let you go if they're asking you to come into work and you're saying no. But if they do decide to let you go, they would owe you severance. It's not a for-cause termination. It's not insubordination. It's not poor performance. They can't make any claims of misconduct, for example. Clearly, you've been working for the last 4 years remotely. Clearly, that is now a term of your employment. You're allowed to do it, right? If, however, they are asking you to come back into work and you are unable to, you can't do it because you're not living in the same location anymore, well, that's unfortunate. That's difficult. Your employer can say, okay, well, if that's the case, we're going to let you go. I hate to say it, Snipple, there's nothing illegal about that if they pay the proper amount of severance. So ultimately, Snipple, you cannot protect your job necessarily for 100% in a situation like that. It may cost you your job, but you would be owed severance. I've seen lots of employers in these kinds of situations take the position that not coming into the office is somehow misconduct or insubordination and refuse to offer severance to those employees who didn't come in. That is incorrect. That is illegal. You are going to be owed severance. It's going to be based on your age, position, and years of service. And again, especially if you're a longer term employee, severance could be very, very significant. If there is some sort of mediation process or conversation, even that you and your employer can have to try and find some common ground. Maybe it's coming into the office and traveling to come into the office once or twice a month, or maybe it's some other position that you can do remotely instead of the position you have right now. Don't be shy to have those kinds of conversations. Make the effort, in other words, Snipple, to and let them know I want to keep my job. I'm committed to the company, but having now moved, there's no possible way that I could come into the office like you're asking. Hopefully, they play ball in some degree. Hopefully, there is some middle ground there that could be reached and you can continue your employment. If there is no middle ground and it's a black and white, either you come into the office or you're let go, that's the situation you're going to find yourself in, Snipple, but you will be owed severance unequivocally. If your employer lets you go and offers you a severance package, or if, heaven forbid, they don't offer you any kind of severance at all, you know where to find us. Give us a call, and we can help you assess the severance that you've been offered and assess ultimately what your proper severance entitlements are. All right, up next is Myron or Miron. Are you located in Ontario, Canada? We absolutely are. We've got offices in Ottawa and Toronto, and in, by the way, Calgary and British Columbia and Vancouver as well. So if you're in any one of those provinces and dealing with an employment law issue, don't be shy to reach out. Keep in mind, you could be anywhere in the provinces of British Columbia, Alberta, or Ontario. We don't necessarily need an office in your specific city or town or a geographic region. Lots of things are done, of course, remotely nowadays. We can certainly video conference and meet face to face, so to speak. And lots of our conversations are done over the phone. There's absolutely nothing wrong with that. And so we can help anyone in those provinces, regardless of whether we've got an office in your particular city. All right, up next, and we've got a couple of minutes left here, guys, so we will go through these questions a little more quickly. Thank you, by the way, to those of you that have posted. Great information, or great questions, rather. I hope I've started you on the way of resolving what issues you're having at work. And I also guarantee you, by asking your question, you've helped others that are tuning in as well, maybe a little bit too shy to ask questions themselves, but are dealing with similar situations. So not only are you helping yourself, you're helping others as well. Lindsay asks, I've received mileage for my job, a sales job, for the last few years. My bosses recently said they are going to stop doing this. Can they just expect us to start covering travel expenses? Great question, Lindsay. Something that happens often. Listen, changes in the workplace happen all the time. If the changes are relatively minor and they don't have really any or a very small impact on your work, then employers are typically allowed to make changes. Nobody's job terms and responsibilities are set in stone forever. But when they start to cost the employee money, and when those changes become significant, that is when the employee is going to have the right to say, well, now we've got a problem here. We've got to deal with this. And so, Lindsay, in your case, if that mileage, if you're, on the road for your sales job very often, and mileage is a decent component of the money that you're receiving from your employer because you're on the road so much, and not receiving this mileage is going to be a pretty big expense that you're going to have to incur yourself. That is a problem. Your employer cannot do that unilaterally. There needs to be a give and take there. So maybe you ask for, if they're going to stop, paying you mileage out, right? Maybe you ask for a raise in response or some sort of other compensation in response to make up for those expenses. And if they refuse to do so, it may be, Lindsay, something we call a constructive dismissal. I was referring to it when talking about kind of harassment and a poisoned work environment with respect to Bill's question, but a change to your compensation can also be a breach of contract. And that it can also give you the right to stand up for yourself and say, no, I'm not accepting this change. And if the employer wants to force it through, you might be owed severance. Lindsay, these conversations with employers can get a little heated depending on your employer. Your employer may be very reasonable. They may be a little bit more stubborn, maybe a bit of an egomaniac. You have to be very careful in those kinds of situations. I would recommend that we have a conversation first. Let's figure out a game plan and a strategy. How do I approach this? What do I say exactly? How do I have these kinds of conversations with my employer? And then you can speak to your employer armed with that knowledge and that background and that know-how as to what to say and what not to say. But I would not accept the change, the removal of that mileage pay. Don't just eat those expenses. That's almost certainly not something that your employer can do. Jacob asks, I am in BC. Do you see cases here with WCB? If that's workers' compensation, Jacob, we can assist, I believe, in BC. Give us a call at the office in Vancouver, and we can certainly tell you if we can help in your specific situation. Sometimes we can, sometimes we can't. Renee is up next. Last couple of questions, guys. Renee is up next and asks, is a full and final release valid if no consideration is given for signing it? Great question, Renee, very specific. If there is no consideration, meaning you didn't really receive anything for signing that document, then no, it wouldn't be valid per se. Again, the devil, I've said this more than once now, the devil is in the details, Renee. So I'd want to look at your particular situation and know exactly why that release was signed, whether you received anything, in fact, for it or not. Sometimes it could take very, very little for a release to be enforceable. So you've got to be careful there. Maybe you did receive something that validates it. Maybe you didn't. It's worth a conversation. So don't be shy to reach out to us, but you're thinking the right way. Consideration is something that basically binds two parties to a contract. It's the give and take that is the very root of what a contract is. And if you don't receive anything in exchange for signing a release, it may invalidate it, certainly. All right, last on the list. We're a couple of minutes overdue here, but we're going to get to her because she was very patient. Linda asks, what do I do if my employer isn't bringing me back from maternity leave? We see this often, Linda. How long do I have to wait before I'm classified as fire? Linda, not very long. If you were due to return and that date has come and gone and it's been a couple of weeks and your employer's still not returning you and obviously not paying you if that's the case, and maybe you're now going without pay because your employment insurance has run out, that is a red flag situation, Linda. They have to bring you back right away. Let's have a conversation about how to do that. And I've been in situations personally myself where I've contacted employers myself about employees in your exact situation and said, either you bring her back to work immediately or we are going to have to get involved. And that's worked before. So give us a call at the office. Again, send us an email if that's more convenient, help@employmentlawyer.ca. But that is a act now situation, Linda. You don't want to wait. If it's been a couple of weeks already, you don't want to wait any longer. Thank you all for tuning in. It's been a really good segment this week. Thank you for all the questions. Have yourselves a great rest of the week. I believe there's another live stream coming tomorrow. So if you didn't get to ask your question today, go ahead and tune in tomorrow and go ahead and get that workplace issue sorted. Have yourselves a good rest of the day, everyone. Take care.